Welcome to the first edition of ECHR Judicial Dialogue. Today's guest is Erik Wennerström, a Swedish judge and legal scholar with a distinguished career spanning academia, government service and international justice. He holds a Master of Laws and Doctor of Laws from Uppsala University, where his research focused on international and EU law. After early work as a lecturer in public law, he served in several senior roles within the Swedish Ministry of Foreign Affairs and the Ministry of Justice, including as principal legal advisor on international law. From 2012 to 2019, he was Director General of the Swedish National Council for Crime Prevention. In 2019, he was elected judge of the European Court of Human Rights representing Sweden, where he has since contributed to the court's work on fundamental rights protection and the rule of law. Currently, he serves as Vice President of the court's first section.
Dear Judge Wennerström, thank you for accepting our invitation to this interview today. Welcome to Trier. It's a great pleasure to talk to you.
Thank you for having me here.
I trust all legal professionals will find this interview very timely, not only because of the EU accession to the European Convention of Human Rights is on the agenda again, but also because there have been major reforms, major procedural and case management reforms in the last 5 years to tackle the backlog and other challenges the court faces. From your perspective, which recent initiative of reform stands out as particularly significant?
It's a very good question. Thank you very much. I think of a handful of recent initiatives that have been taken that has had major impact on the way that our case management takes place. One of them concerns the sorting of applications into different categories to facilitate the management of cases, notably the applications pertaining to what we call well-established case law, something you can recognize as the application comes into the court, that this belongs to a big category of applications that we already have on stock. Now, such applications can be dealt with by committees of 3 judges instead of a full formation of 7 judges, which is a great facilitation of their management. The judgments themselves pertaining to well-established case law can also be very succinct in that they are, as the name implies, well-established. In addition to that, I would like to mention our knowledge sharing platform, which was launched some couple of years ago. The knowledge sharing platform is actually started as the internal tool that lawyers and judges in the court use in order to navigate in our case law on different articles. And it's such a good tool for us that we decided to open it up to the public, to make it possible for European lawyers, judges all over Europe to have access to the same resources that we in the court have when we try to navigate in the case law. If I may mention 2 more initiatives that I think are significant here, I should say the Superior Courts Network. The Superior Courts Network has been up and running for a little more than 10 years now, and it's a network with a hub at our court, joining together 111 superior courts in the 46 member states, plus 5 observer courts from other worlds. In this network, it is possible to exchange knowledge, experiences, pose questions to the court in Strasbourg, and from the court in Strasbourg to the national jurisdictions, greatly facilitating our dialogue and understanding of each other's systems. And lastly, Protocol 16. Protocol 16, which has entered into force makes it possible for the court in Strasbourg to issue advisory opinions, something we have had roughly 10 requests to do so far. It is another instrument in the dialogue between the court in Strasbourg and the national jurisdictions that I think has a lot speaking for it for the future.
Well, not all member states have ratified this protocol.
No, that is correct.
So do you see that there is a movement in this? Will there be, is there ongoing procedure, ongoing discussions on ratifying more countries?
There has been, during my 6 years at the court, there has been a gradual increase of the ratifications of Protocol 16. And I know, being from Sweden myself, I know that Sweden joined roughly a year ago the system. So little by little, the interest for this judicial tool is increasing, I would say.
Do you see that the judges who are already enabled to ask this kind of preliminary reference advisory opinion from the European Court of Human Rights, are there? Do they know how to do that? Do they write proper motions?
Now, this is something that I have already suggested when I speak to academia. Suggested that there should be articles, if not theses, written about how do you find the right language in such a system, how to pose a question, and how do we, as judges of the European Court of Human Rights, respond in an advisory fashion, whereas we are used to do so in a litigation form. Mm-hmm. So we have to. It doesn't come overnight. Finding the right language it takes some time to adjust to that.
You mentioned the digital tools that now open for the public. They have more possibilities to do search in the case note of the court. And we know that both the European and the national courts have been making increasing use of all the digital tools. How are the technologies influencing the European Court of Human Rights' daily work and internal processes?
This is very much, as you say, linked to the case management and the fact that we are dealing with massive flows. I mean, we are currently a bit over 60,000 pending applications in the stock of the court, so to speak. So it requires extensive digital systems in order to manage this in such a way that you can make sense of it. But in addition to that, we have made some hard but very valuable experiences in recent years, also during the pandemic, for instance, where we quickly adapted our ways of office working in general, but also conducting hearings and deliberations in a more digital environment if the need should arise. And we managed to do that in a very rapid fashion, I should say. But also communicating between the court and thinking of Ukraine now, a conflict zone. There's an ongoing conflict with touching the judiciary with which you are communicating. Mm-hmm. What extra requirements does that put on our skills? And we have adapted and solved that as well. So I think that is you're absolutely right in saying that this has had major impact on the way that we work.
Some observers also point out the ability of AI to assist with administrative and analytical tasks within the judiciary. How do you view the role of AI in supporting judicial decision-making in the European Court of Human Rights?
This is touching every aspect of life at the moment, and certainly also the life in a court. And we do not use it in substantive judicial work at our courts, at least not yet. I mean, as a language tool, yes, we are using artificial intelligence, but as a decision-making tool, no, we are not using that. One of the reasons why we haven't done that is the fact that we still haven't ruled on any cases related to AI as a decision-making tool, mm-hmm. and whether it's compatible with the rights concerned. Think of, for instance, Article 14, the risk for discrimination. We know that most AI models are constructed in such a way that it is the predicting based upon past experience of what the next word in a particular line is going to be. Will that generate risks for prejudices or biases? We still don't know that. What about if we were to permit artificial intelligence as a decision-making tool? Would it be possible to challenge those decisions in an intelligent way? I mean, that would require, how do you scrutinize an automated decision-making procedure? It would mean having to get behind the codes, the algorithms, in order to see whether they were capable of producing a fair reply. Now, I know for one that I wouldn't be able to do that as a lawyer with the knowledge I have currently, to scrutinize an algorithm. I mean, it would require completely different skills. We still haven't seen this, and until we do have a standard to apply in these matters, I would see it challenging to start using it for judicial decisions in the court.
But have you noticed that maybe the applicants are using AI, and from the wording or the way they write their petitions, that they already there is already an extensive use by legal professionals?
You can occasionally see that, especially when references are made to case law that one is familiar with, and the way that the references are made are sometimes just coincidentally very much like another reference that you have seen. But that is not surprising. That is also the part of the legal profession, to reuse and recycle cases in such a way that it sometimes becomes repetitive.
The European Court of Human Rights and the Court of Justice of the EU share responsibility for safeguarding fundamental rights in Europe, at least in the European Union. How would you describe the current relationship between the two courts and the way they complement each other in their case law?
I would say that it is as you suggest also in your question, it is a shared responsibility between the two courts, and it's a complementary relationship in that we have different responsibilities. We come in at different stages of procedures in the national systems. Our court usually comes in ex post when the decision making has been completed in the national procedures, whereas the usual way for issues to be raised in the Luxembourg court would be in the midst of a national procedure while it's still ongoing. So it's a bit different perspectives but there is more that is alike between the courts. I mean, it's the same values. It's the rule of law, democracy, and human rights. It's a common set of two courts and a common set of values, I would say. We do this. We see this in the way that we are working when we are EU member states that are also convention states for our court are using EU law in a case that ends up before us. And this is where we have developed I'm sure you're familiar with the Bosphorus doctrine, which is a rule of presumption that any EU law is we presume its fundamental rights protected. That is equivalent to what the convention standards expect until otherwise proven. So we have adapted to each other's way of working, I would say. There's also a constant dialogue between our courts. You can see this dialogue in case law from both courts. In our court, we use references to European consensus when we are looking for or trends in administrative practices. that where we are trying to say what is the current thrust of where is Europe going on this. We are on several occasions we have also underlined the importance of the fundamental rights protection in the EU by making references to the possibility that EU member states have of making preliminary references to the court in Luxembourg on some issues. You can see that in cases like Satakunnan Markkinapörssi versus Finland or Ferro Quintana versus Spain. Another example of the parallelism of the two systems is perhaps clear in the tandem way that the case law concerning the rule of law backsliding in Poland was produced. The two courts had similar issues raised before them at the same time and produced case law on that issue at a pace that was, in my view, impressive.
The timing was also very interesting. How the courts started to refer to each other's case, and there was the case with the Icelandic case that was a pretty milestone for Polish judges to rep to it, and then it was coming back at the as a reference by the Court of Justice.
Exactly. You had the two systems had one the starting points. In the Strasbourg case, as you say, it was the Icelandic judges in 2020, I believe the case was, and in the Luxembourg case, it was the Portuguese judges, I believe, in a case that was the starting point and set the standards that were later applied in the rule of law cases concerning Poland. But you also have this dialogue in a more direct fashion, that we actually go and see each other once a year. Most recently in November, my court visited Luxembourg, and we spent a day and a half together discussing different parts of our case law, trends in our case law, and exchange experiences, which is extremely valuable. As we occasionally have similar issues coming before the two courts from different angles.
I'm sure that there are a lot of legal professionals, judges, lawyers who are watching this interview, and they are very much interested. From your perspective, what opportunities could EU accession to the Convention offer for further harmonizing human rights protection frameworks across Europe?
Thank you very much. I wish I could elaborate on this question, but as you know, this process is currently in the hands of the court in Luxembourg by way of a request for an opinion submitted by the European Commission in November last year. So I do not think it would be appropriate for me to comment on extensively at this juncture, but let me just limit my comment to say that to me, it is evident that the accession would be a way of reinforcing these common values and ensure legal certainty and consistency of protection of fundamental rights in Europe in the long run. But I would have to limit my comment to that.
Thank you. And sorry for this question. I needed to ask for our viewers. And of course, I understand that everyone is waiting for this opinion with knowing what happened in the past, that they're looking forward to what's going to be coming out from the Court of Justice this time. You mentioned that we discussed that of course the courts are living in a very political environment sometimes. We mentioned just the Polish courts. Also, the European Court of Human Rights operates in a very complex political environment. How does the court navigate this space while remaining faithful to its judicial mandate?
I have seen firsthand only 6 years of this this experience, but it goes back 75 years or more, the convention system now. And if we look at the timeline, we could see that when the convention system starts, you could probably almost still smell the gunpowder in Europe from the Second World War. The system was born in that climate. Going into the Cold War, it survived the Cold War and the constant threat of mutual destruction. The post-Cold War world as well, and it has withstood the challenges of these dramatic geopolitical developments. Now, one thing that we can see for sure is it's not the same Europe today as it was in 1950. So during those 75 years, the convention system has evolved, and it has evolved through the 16 protocols that have amended and supplemented the convention, initiated by the states parties to the convention when different matters such as the abolishment of the death penalty has been received sufficient political support to become. Then it happens as a protocol, or two protocols actually, to make that part of the human rights catalogue as well. But it's also been the development in case law, but where the court is trying to keep pace with the developments in society, so that we are not applying yesterday's societal standards when we are adjudicating cases. And I think that the 75 years of successful implementation of this system is the result of the fact that the actors on different sides, the political sphere and the judicial sphere, have stuck to their different roles in this system of separation of powers.
You mentioned the different roles and different players in this field. Non-implementation of judgments by some states remains a concern raised by observers. As a former Hungarian judge, I can mention the Vaka case as an example, which has been for many, many years not being fully implemented and criticized at the Committee of Ministers. Does the court engage with the Committee of Ministers and national authorities to encourage full execution of judgments?
Thank you very much. And it's a very good follow-on of the separation of powers issue that we just discussed. Though the court does not directly participate in any exchanges with the Committee of Ministers when it comes to the execution of judgments. That is the system of separating powers that we have in Strasbourg. The states are the executioners of the judgments, whereas we are the adjudicators of the judgments. But indirectly, I should say that the court assists occasionally in the execution of judgments through the way in which we draft judgments occasionally. Now there are several ways of doing that. In most judgments that the court issues, where the court finds a violation, you will see that the last operative part of the judgment, the Article 41 is referred to, whether damages are to be paid or not. It usually doesn't go to very great lengths of saying what was wrong in the system that generated this violation. But occasionally, for instance, in a so-called pilot judgment, if you were to look at the Walesa versus Poland case from November 23, you look at the Article 41 segment of that case, you will see quite an extensive description of exactly what the court sees as the mechanisms in the country in question which generated the violation that we are ruling upon. Now, this is, of course, intended to assist in alleviating any challenges that generated the violations in the future. So you can say that we are indirectly facilitating execution in that way. The rarest form, you can say that the court is facilitating the execution under the Article 46 procedures, the infringement procedures, which we have only used twice to date, to the best of my knowledge, in the Mammadov case against Azerbaijan, and then in the Kavala case against Turkey. Now, these procedures are, it's really the Committee of Ministers turning to the court, asking whether the non-execution of a case is actually an infringement of the obligations on the convention or not, and the court assesses and then replies to the Committee of Ministers. So in that sense, you can say that we are assisting in the execution. But there, if I may, there is a dialogue between the registry of the court and the Department of Execution of the Council of Europe. Yeah, exactly. So at lawyers' level, not judges' level, but lawyers' level, there is an exchange directly between the registry of our court and the execution department under the Committee of Ministers. Now, this was institutionalized last year only, having been tried for some time, but the results so far are very encouraging, and it's seen as a very positive step indeed.
Thank you. We discussed earlier the European Court of Human Rights and the Court of Justice, and it reminded me that ERA has not so new initiative already. We've been doing it for 3 years, the Young European Lawyers Academy, when we are inviting for an 8-day intensive course, 35 young lawyers in the beginning of their career. And they are engaged in different activities. Of course, they're learning a lot about EU law, but it also includes a visit to the Court of Justice in Luxembourg, and also a visit then to Strasbourg, to the European Court of Human Rights. Then they have the chance to meet judges from the European Court of Human Rights and the European Court of Justice. Of course, unfortunately, not all legal professionals, not all young legal professionals have this opportunity. But what advice would you give to young legal professionals or law students for their future career?
This is quite a responsibility in answering this question, but I welcome the fact that you pose it nevertheless. Well, let me give you 2 ideas that you may seek comfort or even inspiration from. At times, especially in the beginning of one's career, it may be difficult to see what impact the role I, as an individual, am able to play. And to give some sort of comfort to those who feel lost in such a way, let me say that you are, as a lawyer in the future, you will not only be the technician of a system, whether you are in private practice or in government practice or in judicial practice. As law always evolved, you will actually become an architect of the future system too, no matter which role you play. So your role is always more important than you think as a young lawyer. From the very first, when you start to provide briefs to other judges, your superiors, or you write articles, you are not just restating the law, you're actually shaping the law as well. You are one of the architects from day one when you enter the legal profession. And that's quite a responsibility, but it's also an opportunity.
Yes.
The second part of my advice would be to take comfort from the fact that even when things look dark, even when there will be anti-judicial sentiments here and there in the world, my belief is that the rule of law has always existed in parallel to such sentiments. And this is an observation I make going back to the Roman Republic. Cicero and his writings, which are definitely influencing the way that we see the rule of law today, he writes them at the same time as Caesar and the triumvirate is dismantling all the functions of the Roman Republic. The two exist at the same time. One does not exclude the other. They don't die all of a sudden. They coexist. Sometimes they are stronger, sometimes they are weaker, but they exist at the same time. And you are an architect working on that system. So would be my advice.
Thank you. Thank you for the opportunity to have this discussion with the Judicial Dialogue.
Thank you so much for having me here. It's been a pleasure.